Good morning, Jack.
Morning, Bob.
This morning, let's talk about the Supreme Court decision on universal injunctions, obviously relating to, but not focused on the constitutionality of the birthright citizenship executive order. And I want to zero in right away on your piece, the piece that you've published on executive functions, and then broaden that conversation out a little bit. So why don't we start with your stating, in a nutshell, what your fundamental argument is?
Sure. I published a piece that made three basic points. The first one was this was not a shocking or ungrounded or radical decision in the sense that many justices had signaled that this was their view for many years across many administrations. The Biden administration took the view that universal injunctions were unlawful. The Solicitor General, 20 days before, 21 days before Trump became president, on the way out the door, in the alternative, in an application for an interim order, asked the court to grant certiorari to rule on universal injunctions, and she made many of the same arguments that the court made in the majority. Even Justice Sotomayor, in her dissent, acknowledges that in the typical case, there are problems with universal injunctions. I just don't think this was a surprising opinion, and that was the first point. The second point was that the impact of the decision is really up in the air. The court eliminated universal relief via injunctions, which was something that had really gotten, I think it's fair to say, out of control in the last 10 or 12 years. But it left open many other avenues for universal relief: class actions, Section 706 vacator, complete relief to the parties, invisible remedies. And it's just an open question now, which we're going to see litigated, whether these other avenues of universal relief are available and how complete they will be in in bringing the executive branch to heel. And the third point, and really the main point of the piece, was to point out what I thought was an extraordinary concession by the Solicitor General. I wrote about this a month ago. At oral argument, the Solicitor General said 5 or 6 times in response to questions from many justices that he would respect the judgments and opinions of the Supreme Court. And I take that to be on a universal basis, i.e., that whether or not the Supreme Court's judgments themselves have universal effect, their opinions will be respected by the government, and the judgments will be respected by the government. He didn't say why, but he acknowledged that they would, and Justice Barrett put that kind of marker down in a footnote in her opinion. I think this is a hugely important point for a couple of reasons. We can discuss it more, but I'll just get them out. One is it's amazing. This is a concession that no administration in the history of the country, as far as I can tell, has ever made. Certainly not like this. It is an extraordinary acknowledgement, in my view, of the power of the court. The reason that Sauer had to make the concession was, and he went into the oral argument knowing he had to make it, was because there's this question: if the lower courts can only give relief to the parties, which is what basically the elimination of universal injunctions mean, then what's to keep the executive branch from acting lawlessly for against people who can't sue for whatever reason? And Sauer's answer was, don't worry, Supreme Court, you can tell us what to do and we'll listen. Now, he didn't say why. He didn't say what the legal basis was or whether it was a practical accommodation or what, but it was an amazing concession. And that's why I concluded that these reasons are on the whole why I thought it was mostly a win for the court and not. I said it was also a win for Trump, but the real winner was the Supreme Court.
Just for a second, let's focus on, just to clarify points, the difference between a judgment and an opinion. So, judgments and opinions, he stated, were ones that the administration vowed to respect. That is to say, if issued by the Supreme Court. And you're focusing here on opinions and not judgments. Can you just talk about that for a second?
Well, I'm not, it's not clear. It's not clear. I mean, when he said judgments and opinions, I think what he meant was there's an old debate going back to the beginning about the extent to which presidents have to comply with what the Supreme Court says. And some people, Lincoln took the view, for example, um, that there had to be compliance with a judgment of the court in the particular case, but that the precedent of the opinion, I'm elaborating a little bit on what Lincoln said, in a terrible case wasn't necessarily binding on others. So he was distinguishing between judgments and opinions. And some of the literature on this makes that distinction. It's not clear what Sauer meant, but in terms of exactly what he meant, but the bottom line was, and I'll focus on opinions, I think, and this was clear at oral argument, which Barrett was referencing. The bottom line is that when the Supreme Court pronounces on what the law is in a particular area, the executive branch will respect that in other cases. I think that's the bottom line of what he was saying, which is really a form of universal relief, which is one of the great ironies of the opinion and why that was kind of buried in a footnote. I don't know why the dissents didn't make more of what I see as a tension between the court's insistence at oral argument through questioning and putting that in the footnote and the little universal injunction it slipped in at the end of its opinion. There's a bit of a contradiction between or tension between the court saying only relief against the parties, but they're kind of withholding for themselves forms of broader universal relief to which Sauer uh, conceded, I think.
So somebody might ask, what does it mean that he made this concession? He made the concession, the court sort of jumped on it, but the administration isn't bound by what he said, which is to say that they could switch positions later, opportunistically as they chose. And that's clear too, right? So you write in your piece, now this concession, for the first time in your knowledge in American history, goes into the Supreme Court reports. There it is, the administration saying your pronouncements on constitutional law, on a constitutional legal issue are binding on us. That's today, but in this volatile Trump administration, and we've commented on, its lawless ways, what does it really amount to? What weight do we give that?
Well, we'll see, but I'll say this. You're absolutely right. It's open to the Trump administration tomorrow to fire John Sauer and to say, we don't care what Sauer said, and we don't care what you say in your opinions. We're not going to comply with your opinions. I don't think that's going to happen. The first question you have to ask yourself is, why did Sauer make this concession, this unprecedented, extraordinary concession? It really shows that the executive branch cares about the power of the court and needed to accommodate it to get what it wanted from the court. That's the first thing, which is amazing. The second thing is, you're right that who knows what Donald Trump can do whatever he wants, as we've learned, and he can change on a dime and fire someone. I have no doubt that that concession by Sauer was vetted in the White House. That seems very clear, but they could change their minds in a moment. However, that was always true, and that's going to be true no matter what the court says. If the court says we hereby order the administration to comply with our decision on a universal basis, and that's what we really think unanimously, it's still open to Trump to say screw you. So that's always the case. The question is, has the court put itself in a better and stronger position vis-a-vis the Trump administration by extracting this concession from the Solicitor General and putting it in the pages of the U.S. reports? I think the answer to that question is yes, because I do think that the costs are now going to be clearer and higher to the Trump administration doing that. I'm not saying it won't, but I do think the court has put itself in a stronger position and really, again, just to repeat, in an extraordinary way, given that this has never really been a conversation between the court and the executive branch. And now we've had this conversation and we've had this concession from the executive branch, and it's in the US reports in a context of all places of the Trump administration.
Yes, but sort of can't you turn that around, Jack, and say it is precisely because of the Trump administration that the court felt that it needed to extract that concession?
Yeah,
I mean,
absolutely. Absolutely.
yes.
That's 100% true. Well, that's why they were asking Sauer the question. And it's also extraordinary that the executive branch realized they needed to make the concession. I mean, that's really, I mean, why does the Trump administration need to concede anything to the US Supreme Court? Why does it care what the Supreme Court says? It's a
Presumably
great question.
because Howard wanted to win the case, right? And he realized that
But why do they care about winning the case? They care about winning the case because it makes a difference to how they can operate, whether the Supreme Court agrees or disagrees with them. That's the
well,
real lesson here, I think.
well, that is certainly true. I think they want to win where they can win because that's extremely helpful. And we know from, Stephen Miller's, White House long pronouncements on what the Supreme Court did or didn't do in the administration's favor. They certainly want to go to the cameras and say that they've been vindicated. But if they run up against resistance, we know, they are prepared to attack the courts. And so the Supreme Court must know that there's a possibility here that this deal, if you will, won't hold under other pressures.
I agree. I wouldn't call it a deal. It's an implicit deal.
An implicit deal,
The,
yes.
the court, I don't know what the court thinks. All I know is that as between a position where the Trump administration has not acknowledged that it has to comply with Supreme Court opinions, and a position where the Trump administration has acknowledged it, and that acknowledgement is in the pages of the Supreme Court reporter. First of all, it's a remarkable testament to the court's power that the Trump administration needed to do that. And second of all, I just think the court's in a better position with that concession than without it. I acknowledge that there's no force from emanating from the Supreme Court building that can force a president to comply with its orders. And it's always been a legal mystery from the beginning of the nation why presidents comply with Supreme Court decisions. But I still think it's a remarkable concession and placement in the pages of the U.S. reports.
Let's move to the sort of the heart of a surprise, disappointment, complaint that you hear among critics of the court. And that is that they've treated this issue before the court as, as you point out, a critical question of the authority of federal courts, lower federal courts to issue universal injunctions. And all well and good, and prior administrations have expressed, including the Biden administration, unhappiness with that state of affairs, with federal courts taking on the authority or assuming the authority to do that. But this was an extraordinary case involving an order that was patently illegal. I don't know that I read anywhere any serious commentary to the contrary. And what the court did was leave that background concern about this extraordinary order, this extraordinarily illegal order in the background, and sort of proceeded to treat it like, you know, yes, of course it mattered, but what was really important was to settle this question of nationwide injunctions and the power of federal district courts to issue them. There's not a hint in this case, in this opinion, uh, about the merits of the matter.
Right.
And as you point out at the very beginning, now everything's left up in the air. Nobody knows, for example, what authority the lower courts have in resolving the constitutional issues to apply the relief on some sort of nationwide uniform basis. Isn't that a problem with this opinion? That it just doesn't meet the moment?
I'm not sure what meeting the moment means. I mean, I agree that the executive order is unconstitutional. It seems clearly unconstitutional to me. There is some serious commentary defending it on defending the order on originalist grounds. But I just think, given what the Supreme Court has said about the 14th Amendment birthright citizenship clause and the practice of the political branches, I just think it's going to be a losing proposition in the Supreme Court when it gets there. Um, I do think, though, it's important that, and again, this is an extreme case, but presidents are allowed, and they do it all the time. Every administration does it to some degree, to seek to change the Supreme Court's understandings of the law. And they do this through litigation that pushes the bounds of the law and seeks to get the court to change the law. Again, every administration does this. The question in the case is, what are the rules? This is an extreme case, I agree, but what are the rules when administrations try to do that? Um, as for how dangerous it is, I just think it really does leave things up in the air in terms of, and it's completely open to the court to shut this down when it wants. And so we'll just see what happens on remand. But when you talk about it being dangerous, I mean, that takes a view on the merits. The court explicitly, and I think obviously self-consciously, declined to make that issue part of the case. They focused just on the universal injunction issue, not on the birthright citizenship issue. It wasn't presented. It wasn't relevant to the court's legal analysis. Now, Justice Sotomayor had a different view. She thought it was relevant, but for the court, it wasn't relevant. And again, this is an extreme case, but it's not unusual for an executive branch to try to get the court to change its mind about something. The hard question is, when the executive branch proposes to do something that's illegal under current law, what are the interim rules in the 2 or 3 years it takes for the Supreme Court to address the issue? And we'll see on that. We don't know, given that nationwide injunctions are gone, whether these other mechanisms, how broad relief they'll provide.
Right. But you agree then, or you sort of suggesting then, that we're in for a 2 or 3 year period of uncertainty.
I don't think it. No, no, no. I think it takes two or
You're
three.
gonna,
It
okay.
takes 2 or 3 years from the time of trial, typically, sometimes it's months, from the time of trial to get a Supreme Court decision. But we're going to now see efforts for nationwide class actions. The court remanded on the question of whether complete relief to the states, in this case as plaintiffs, basically amounted to a functional universal injunction or universal relief. I think we're going to get answers to these questions soon, because there will be lower court skirmishes and there will be requests for emergency relief in the Supreme Court, and it's going to have to address these issues probably, perhaps before the end of the summer. I mean, the rubber's going to hit the road in 27 days when the court said, in issuing its what I feel is a universal injunction, the court said that the Trump administration couldn't implement the executive order for 30 days, and that's about 27 days from now. And at that point, I think we're going to start seeing other injunctions or other efforts to use mechanisms of universal relief to stop this. So again, it's hard to predict. It's hard to predict whether there will be universal relief and how long it will take.
So let me just ask you about the Kavanaugh concurrence in that regard, because that's relevant. Kavanaugh, in his concurrence, says it's my understanding that the court can step in on an interim and emergency basis to resolve this question quickly. Because if it's up to the Supreme Court and not to the lower courts, then the lower court will rise up and sort of address its responsibility. And so that would be the basis for saying, well, then the court can act within 30 days and can shorten the period of uncertainty. But the court didn't. There's not a majority of the court yet that subscribes to what Kavanaugh had to say. That was his understanding expressed in a concurrence. It's absent from the court's opinion. It's certainly not consistent with what Justices Alito and Thomas have indicated is their view. So how much weight should we put on the notion that the court will in fact act so quickly that by the end of the summer, this period of uncertainty will end?
Well, I'm not sure what the court will do when it'll act, but Justice Kavanaugh constitutes the fourth vote, and I expect that I don't know, but I expect that the Chief Justice or Justice Barrett and perhaps others will agree with him. We're going to go through we're going to run the same interim order gamut in when lower courts start issuing universal relief on other bases. And the court is going to have to address the question what the rules are going to be on those forms of universal relief in the interim until it reaches the court on the merits. And it's not going to be able to avoid this question one way or the other. Whether and how it will act, we'll have to see. We'll have to see what the lower courts do. But I do think Justice Kavanaugh's concurrence was insightful in a couple of respects that you hinted at. If anyone thought that eliminating universal injunctions was going to get the Supreme Court out of the business of being bombarded with these interim orders on a fast track, that's not the case, as just for reasons Justice Kavanaugh explained. The court is not going to be able to stay out of this, and I do think it will be acting on these other forms of universal relief that are going to be litigated pretty quickly.
Let me just again ask a question related to Kavanaugh's concurrence and what he had said, or what he said in that concurrence, not appearing in the opinion. Why would that same sense of urgency, that would have been helpful. It would have been short of maybe saying something or hinting at the merits, but why would that same sense of urgency not have appeared in the court's main opinion? Why is Kavanaugh the one sort of solo on the sidelines, giving people the indication that yes, we understand this is an extraordinary moment, and the court is not declining today to take up that challenge?
I can imagine a couple of reasons. One, Justice Barrett's opinion is a very lawyerly opinion, and she sticks to the question presented and tries not to answer questions that aren't presented. And that's a perfectly legitimate way to proceed, obviously. Two, we don't know what it took for her to get the 6 votes to sign on to that opinion. And it could have been that not talking about these other issues, which I think she would be inclined not to talk about anyway, is pretty clear from the opinion. It could be that not talking about those issues was the price to get all the justices on board. So we just don't know, but I don't think there's anything. I mean, it was a very, as I say, lawyerly, and I mean that as a compliment opinion. It emphasized the narrow question before the court. It emphasized the legal issues before the court, and it sought, with the giant exception of the sour footnote and the universal injunction at the end, which are revealing, it sought not to answer questions not presented in the case.
Yes, and that's the basis for the criticism that we see expressed so passionately in Justice Jackson's dissent. Uh, she really has written a kind of this doesn't meet the moment opinion. And I guess her answer to what you just said would be that's precisely the problem. It was a narrow, lawyerly opinion that settled an important question before the court, but without any indication of the extraordinary nature, you use the word extreme, of the position that the administration has taken, the action that it's taken with the executive order on birthright citizenship, and that's a real problem. That a moment like this, the public looks to the court to provide a little bit more guidance, but instead what we got, I suppose you could say, is a master class in remedies.
Yeah, I mean, look, there's just a fundamental, foundational disagreement of judicial philosophy between Justice Jackson and the majority, at least in most respects. Justice Jackson takes the view that the reason courts are there are to say what the law is and to make the executive branch comply with the law, and we shouldn't worry about these procedural niceties and remedy niceties and jurisdictional niceties. Our job is to say what the law is and to make sure the executive branch is complying with the law. That is a law declaration, a broad, robust law declaration conception of the federal judiciary and the Supreme Court. And it's a position that she's not the first person to take, although that is a very robust opinion on that score. And the majority it says, no, I'm sorry, we're not the overseer of the government. This is a theme that didn't start last week. We're not the overseer of the government. We decide cases and controversies. We have to follow the rules. There are often cases, there are many cases where the Supreme Court is faced with an action that is almost certainly unconstitutional, and it says, sorry, we don't have jurisdiction, the plaintiffs don't have standing. The Obamacare challenge in California versus Texas was almost once they eliminated the made the penalty, there no payment for the penalty, and therefore the tax justification for Obamacare went away. In my view, that rendered all of a good chunk of Obamacare, if not all of it, unconstitutional. And there was a strong argument on the merits that was unconstitutional, but the Supreme Court, I think 7-2, said we don't reach the question whether it's unconstitutional because nobody has standing. So this is not something that just happens in the right direction. It's often the case that the Supreme Court doesn't address an issue on the merits because of some jurisdictional or procedural or remedy or limit on the federal judiciary. And that's the position of the majority. So there's just a foundational difference between what the role of the courts is.
Yes. But I think some people would say there are times when the court does stretch a little bit, and it
Yes.
just chose here not to do so. And that's one of the criticisms of the court, that the behavior of this administration overall has been so extreme. And this, that is to say, in matters of constitutional, and other legal concern, and that in this case in particular, this executive order is so patently unlawful that there was some hope that the court would, if you will, stretch a little bit here. And that brings me to Sotomayor's dissent. Let me ask you this
Oh,
question.
let me just say one thing about that.
Yeah,
Then
please.
I do want to talk about the Sotomayor dissent. Um, so you're talking about meeting the moment. What should the court have stood up to the Trump administration and it could have hinted, even though it wasn't presented, or said something more. Sorry, this is unacceptable behavior. Okay, I just don't think that on the majority view, which is more or less the view I hold, I just don't think that's the role of the Supreme Court, and they said that. Just from a strategic point of view, not at all clear that in this extremely complicated, delicate game that the Supreme Court is playing with this very aggressive, threatening executive branch, it's not at all clear that that's a very good strategy. Not at all clear. And it might be the better strategy to stay within its lanes, reserving to itself all sorts of tools to crack down on the executive branch if it needs to, but not unnecessarily to give Trump his win on an issue that the court has been inclined to reach for a decade now. And so just from a strategic point of view, it may have been satisfying to some if the court had gotten up and said, "Boy, the Trump administration, you shouldn't be doing this awful thing." But that just that was not the court's role in this case, and I think it's perfectly defensible, even from a strategic perspective, for the court to proceed as it did. It's hard to know, but I think it's perfectly defensible.
And yet, as I said earlier, I mean, the court could have at least, and this wouldn't have been, particularly aggressive. They could have made it clear that they weren't going to let this go on forever, which is essentially the thrust of what Kavanaugh said in his concurrence, and it stayed away even from that. And I think that, that concerns people on this sort of meet the moment theory. But on the Sotomayor dissent along the same lines, Sotomayor makes, it seems to me, a very strong lawyerly point, which is how does the government establish, for purposes of this proceeding, irreparable harm because it is not permitted to begin to prepare to implement a patently unlawful order? And she makes much of that at the very beginning of her dissent. She writes, I think, pretty astutely on that point. How did you read what she said and the strength of the argument that she made?
So first of all, let me say I think it's worth carefully reading Justice Sotomayor's dissent. It's much better, in my view, than Justice Jackson's dissent, or at least it meets the majority opinion much more directly. And as I said at the beginning, it was not an attack across the board on universal injunctions. The Sotomayor dissent said, in the typical case, there's a problem here. And that, by the way, as Will Bode said in his blog piece this morning, I suspect that's why Justice Kagan joined this opinion. It was an attack on universal injunctions in the context of what Justice Sotomayor thought was this very extreme, the unconstitutional executive order, and not an attack on universal injunctions generally. On the point that you made about whether the government suffered irreparable harm, I mean, there's just a couple of lawyerly points. First of all, I mean, her point was they did. How could you say, sorry, that the government suffered irreparable harm here when what what it's doing is unconstitutional? That's your question.
Yes.
Justice Barrett's answer was A, it's not presented. B, we often that B, there's a pretty settled rule, and now it's settled in the court because she said it in her majority opinion, drawing on earlier opinions, that the government is always, by definition, harmed when it can't implement its program. And as I said, government executive branches are allowed to pursue courses of action that seeks to get the court to change its mind about constitutional issues. And third of all, the court all the time looks to the irreparable harm issue based on the question presented and not on the ultimate merits of the case. They do this in the death, as Justice Barrett points out, they do this in the death penalty context all the time when they address a particular legal issue in the case and say that a party and analyze whether the party is or isn't irreparably harmed on the legal issue presented and not on the ultimate merits question. So that's a technical answer to a hard question, but I think that's the right answer.
So let me sum up, and then you take your shot at this formulation. Someone who's concerned about this opinion, and I thought that, just to put my cards on the table, I thought that the court's opinion from a strategic point of view and from a craftsmanship point of view was impressive. But I'm still troubled, and here is what I'm troubled by. If we agree that everything has been left up in the air, we agree that the court chose, if you will, to give a master class in remedies and to take the constitutional issue head on. If we agree also that if you take Kavanaugh's view, a resolution should be expected in short order, so we might see sort of a quick end to the pain, to the wait. But if you read the majority opinion and not assume, for example, that all justices in the majority are on board with Kavanaugh, we are looking at the potential of a protracted period of uncertainty. We can speculate that the court is going to step in quickly, that it's going to do what Kavanaugh suggested what we do, but we don't know that it's going to do that. So all the legal options are up in the air, and the timing is up in the air, and in the background is this utterly unconstitutional executive order. And so isn't that a reason for people to walk away with a profound concern about the outcome here? I mean, even if you disagree with them, is that a legitimate way to read the outcome here?
Yes, in the following sense. If you think this is, and I do believe it's an unconstitutional order, and you think it's the worst thing in the world, and if it came into effect, it would be a disaster, then you have reason to worry because there's uncertainty on that question. There's absolutely uncertainty on the question what universal remedies will be available here and what the Supreme Court will do in an interim order basis in the short term about that question. Those are up in the air questions, totally up in the air questions. And so if you take that perspective and you think this is, and if you take basically Justice Jackson's view and even Justice Sotomayor's view, that her view is that whatever you think about universal injunctions and there are reasons not to like them, this is a case where we need one. If you take that view, then you're very worried here. If you take the view that presidents are allowed to challenge constitutional understandings of the Supreme Court, that there are rules that govern what the executive can do in implementing that in the interim before the Supreme Court ultimately rules, and if you say that there's law here and the Supreme Court can't answer every single constitutional question, and oftentimes it lets things go through that are unconstitutional because it simply doesn't have the authority to rule on them because it too, like the executive, is limited by law. If you take that perspective and if you realize that the court has a whole bunch of options here to step in if it thinks something terrible is going on, then it's less worrisome.
Well, we'll leave it there unless you have any concluding comments. And there is a lot to watch for in the months ahead. Hopefully not years, hopefully within the next 30 days.
I think before the end of the summer, this is going to be back at the Supreme. I'm confident it'll be back at the Supreme Court before the end of the summer. So the justices are going to have work vacations.
Very good. Thank you, Jack.
Thanks, Bob.